Good morning, chat. I hope you guys are having a beautiful Friday. I am, for the first time in a while, I actually feel rested, which is crazy. So, but I hope you guys are having a beautiful Friday. I've got my coffee here. Hope you guys have your coffees. And let's let's get ready for the circus. Let's get ready for the circus. You guys ready for this shit? I'm not. Guard it. What's up, man? How you doing, bro? Did you sleep well? Did you get any rest? All right, so I'm going to put a poll out for you guys. This is going to be all day. So let's see. Will there be enough evidence for probable cause? Uh-oh. I got the A and the U backwards. You didn't rest yet? Why, dude? Why? Why are you not doing that? Go to sleep. Go get some sleep. Go get some sleep. All right, real quick, 18 plus stream, 18 plus channel. If you are here under the age of 18, ensure that you have your parent or guardian's permission to be here. If you don't, I'll have to ask you to leave the stream. All right, this is to protect kids. Okay, so appreciate it, guys. All right, so I was looking online last night, as one does. Right, I'm always on my socials. Like I'm perpetually just always on my socials, guys. And I found some interesting things last night. Very interesting things that I want to share with you guys today. So let's see. It should be. I'm pretty sure I reposted. Okay, interesting. So let's see here. All right. I might have to blur some of this out. Maybe. I don't know. I didn't get in trouble with the last one. Okay. All right. So any firearms that I show or any of that nature is for educational purposes only. I have to say that because YouTube is on some shit right now. Okay. I haven't got a notification of anything, but just to be safe, this is for educational purposes only. Okay. All right. So I want to move this over. Okay, so we were looking at the rifle that they were presenting yesterday, and there are some discrepancies. I focused more on trying to make sure that these rifles, I guess, because supposedly they're different, and compare them to actual Car 98s. And someone had actually pointed out some really good they got some really good catches. All right, so take a look at these two scopes here. Take a look at these two scopes. All right, do you guys notice anything? All right, well, what I'm going to do is I'm going to point this out to you guys. Okay, so these two scopes are very different. These are different scopes. I say that because if you look at the magnify, actually here, let me see if I can download this. All right. Oh, looks like I'm gonna have to take a screenshot instead, of course. All right. Okay, so shoo that back over. I'm gonna pull that back up so that we can zoom in here. All right. So you see here, this is what's called a magnifier or a power ring, whatever you want to call it. All right. What it does is it zooms in the scope, right? It's a ring that you turn that adjusts its magnification to whatever you wish it to turn to, right? They are different. Yes, they are. Well, wife is going to volunteer at accounting firm, so gotta stay up. Oh, I got you. Well, I hope you get some rest today, bud. You can see it looks like there are numbers or letters, which is typically or some kind of writing, right? Which is typically an indication that this is a magnifier ring. And a lot of the times you'll have a 1 through whatever number, 8 power, 10 power, 12 power. Uh, so far, what I've seen, anywhere from 8 to 12 power, I think. Could go well beyond that, but that's all that I've really seen. Not to say that that isn't the case. There could be there's more than likely well beyond 12 power, but the only thing that I've seen personally was anywhere from 8 to 10 power, I think. Anyways, so you can see by these dots here, right, that this is a magnifier ring. Okay, so which indicates that this is a 1 to whatever magnification ring. However, if you look here at this one doesn't have that. This one has just what's called grooves, right? And if you also look here, there's a slight discoloration, which means, well, in a line, there's like a line here, and then there's one right here, right? Which tells me that this scope, right, is a very different scope. Because those grooves, right, it doesn't have the same magnification ring that the other one that we just showed you did. What it does instead is it turns this entire section, I guess, except for this here, which is the actual lens, right? But this entire section turns, and I've had rifles that have done this the same things that I'm pointing out to you here. Well, scopes. I'm sorry, magnifier rings, and then also scopes where the entire section has been able to turn to adjust magnification, right? So that's a pretty good indication that these are separate scopes here, which was found yesterday or last night that I just saw. And looking at it, I can't believe I didn't notice this. I can't believe I didn't notice this, but again, there's a lot of stuff that's going on too. Right. So also something to notice here. Um oh, I guess there wouldn't be. Actually, yo chat, doesn't this look steeper? Doesn't this look steeper than this one? I don't I don't see a all right, so the reason I'm saying that is because this looks like a cheek rest. This absolutely looks like a cheek rest here. Whereas this, that doesn't really look like a cheek rest because you could definitely tell that it's more shallow, and this one is more steep, right? But what's the point of all of this? I didn't follow anything after Kirk's death. So supposedly this is the rifle that they took, right? This is the very, like, I don't understand how someone could really pass this off as an actual picture, a professional picture. Dude, my phone camera does better than this. My phone camera literally does better than this, okay? And I know for a fact because I use my phone for my diorama content, okay? There's no shot that this is the best image that they could get. Absolutely not. No. So this is supposedly the rifle that was used, right? Which doesn't make any sense because these scopes and honestly these stocks don't match up either. Something that someone pointed out as well is that this picture here, this stock goes well past this one, or at least that's what I saw, right? So just something to note. And then also I'm gonna play this. I put out a couple of shorts last night of some things to really pay attention to as far as it pertained to yesterday. Does it really matter if it's the same gun or not? I mean, the point is that it's a yes, it does. It absolutely does, right? Um, everything has to match up. Everything does. The scope, the rifle. Um, Because if not, then that really brings into question the um the probable cause. If you cannot prove probable cause, then there's no case, right? Did I like Kirk? I didn't think Kirk was a bad. Now there's a lot of disagreements that I had, right, with Kirk, especially when he was pro our greatest ally. Um, but I started to agree with him a lot more whenever he shifted from the pro greatest ally stance, right? Now, of course, I'm not a religious person. As someone who has studied the Abrahamic religions, especially for years, I know what it says, and I'm not religious because of it. Um, I absolutely disagree with him on a lot of that, right? But I don't think he was a bad guy. I the thing though, right, is I'm not exactly sure, and this is going to be super unpopular, but hear me out. Hear me out, okay? I don't think necessarily Charlie Kirk was a real person. And I say that because there's evidence that points to him being MK Ultra. Okay. If I remember correctly, Candace said that himself, that he was propositioned, or that he actually was MK Ultra. So there's that, and there's also a lot of questionable things that happen with the assassination, right? Mainly being AI. Okay. Um, I've posted links. I can't remember if I posted one to um whatever I had said. Um, yeah, I can't remember or not if I posted a link to one of my X posts, specifically over the AI chair. But what's really interesting to me is that there's so much AI in the footage of the Charlie Kirk assassination that would suggest that if this if this whole thing is faked, if that is faked, then what about Charlie, right? You look at Charlie's wife Erica. Erica knew Erica knew Trump, right? Since 2012, as she was running for Miss Arizona, right? So they've known each other for a long time, but also Erica is very highly connected with the CIA. And I say that because there's evidence of her in training videos, right? How and her father is was also CIA. So how is it that Charlie Kirk didn't know who Erica was all of these years? Supposedly they met in what, 2019, I think. How did he not know who this chick was and had a kid with her? Almost every single picture that their kids are in, completely faceless, right? Some of them even have hats over their heads. That's really strange to me, right? And I agree with protecting your kids, especially on the internet, right? And as high profile as that, but that is very questionable to me. It's very questionable, right? Why hide that identity so much, right? Um, and then it's pretty convenient as to why this whole thing happened when it did, right? I've already pointed out to you guys, I think day one uh, of the same day that Charlie was shot, right? Charlie was shot, that the House Rules Committee voted to seal the e files, okay? Which is very convenient. Very convenient. And a lot of the stuff that's been happening has been to cover up the e files, right? Because it implicates almost the entirety of the government and also a foreign government. right? So it's just very questionable to me, and I don't know if I could show you guys this clip here, um, but there is a chair, right? I don't know if you guys have seen this, but in one of the videos where you can see the security officers working on Charlie after he was hit, you can see them manipulate a chair, and that chair literally clips right through a table. Here, let me see if I can if I can screenshot it. That would actually be pretty great here. Um, Let me see if I can screenshot that. Charlie's not in this image. Charlie isn't in this image. You know what I'm gonna do? Just to be safe. Just to be safe. All right, I'm gonna clip this here, and it's gonna be a little bit difficult to see, um, just because of how zoomed in it is. I'm gonna bring this up for you guys here. So here, there's some clipping, right? This is the leg of the chair. This is the seat of the chair, and you don't see the other leg of the chair, right? You just literally see it clipping through this stand or table here. How do I know it's clipping? It's because I know video games, right? And so when you have something like this, it's called collision, or clipping and collision. Clipping is when an object phases through another object, right? But then you also have collision because this object interacts with this table, right? And then it literally just jolts out of the table itself. Okay, which is weird, right? So that's in one of the that's in the footage. And then you also have this, right? Look at this, look at the distortion on the face. Look at these two faces blended together, right? Here we go. Here's another one. Distorted faces. Um and lastly, and there's even more, but here people it just this looks like a whole mess right here. I mean, it just has anyone ever seen what is it? Kira, I think it's Kira. It was a 1990s anime, and at the end of the anime, this guy turns into a big giant skin blob thing, right? And this is what this looks like. I mean, this just looks like a testicle. I don't even know what the fuck this is, bro. Oh, what is this? Who is this? Is this Kanye during that one meme that people was making fun of him for? What the fuck? But yeah, and then I don't know what this is. Yeah, none of this makes any sense. So if this was faked, right? If this was faked, Akira, that's it. Akira, that's right. I thought it was Kira for some reason. Akira. Um, so if this was faked, what else was faked? Right? It doesn't make any sense. What I have been thinking, and this is just me theorizing, right? And I've been right about a lot of things. I've been right about a lot of things. And this is just me theorizing, right? Given the fact that there was hardly any blood on the security staff, right, that brought him in, there was hardly any blood, or excuse me, any liquids, right? Got to be careful with my wording here. Any liquids in the SUV, and also given the AI that I just showed you here, it's very possible that all of this is faked. Very possible. So if that is faked, then was Charlie even a real person? Knowing what we just talked about, how he was with Erica for so long, had no idea who she was, right? I mean, there's how did he not know? Like, there's so much out there now, right? And no one even knew who Erica was before Charlie died, right? I had no idea that Erica Kirk even existed before Charlie died, which is really weird. Which is very weird. Very, very weird, right? Charlie's rise to popularity was all the way back from what, 2015, 2016, right? When the whole people when people were waking up to the left, right? And realizing how wacky the fucking left is, which yes, I agree. I agree. The left is weird. Okay, the left is absolutely weird and cultish and fascist and all that kind of stuff, right? That they project onto the right, and the right does the same thing, right? But that's where he got his rise, and the whole thing was to keep people divided amongst red and blue, and have people constantly fight each other, fight amongst themselves, right? Um, while taking a blind eye to the actual things that are going on, which we have talked about several times here on the channel. So I want to read a couple of comments here. Let's see. Yeah, but he admitted that they um through text messages, which are very questionable. It's very, if you look back into the text messages, right, where they're using phrasings, or where Tyler supposedly here is using phrasings like "my love," or um or being concerned about his grandpa's rifle, which makes no sense, right? Especially in a time of heightened in a heightened emotional state. That doesn't make any sense at all. It's like it seems as though it's a play, right? And that's not how anyone talks today, right? You're not going to call someone that you're with my love. That's just not a thing. Also, didn't his father turn up? No, no. If I remember correctly, the parents said that they did not turn him in. And there's also some weird things with that too, with the detective that supposedly was there but wasn't there when they apprehended Tyler at the police station. And isn't it also weird how the security cameras cut out right when Tyler showed up? Huh. That's weird. But so supposedly Tyler showed up around 9. But if that's the case, then the agent wasn't there until around midnight. But the agent also said that he was there when Tyler was showing up, which doesn't make any sense. But okay, whatever. So yeah, no, 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 no. That was through text, which matters in court. It matters in court. Okay. If it's not video footage of him saying, "Oh, I did this," then they could it could be anyone who's texting that. We don't really know, right? That's the point of due process. You have to prove that this person did it, right? And using text messages of someone admitting to it doesn't necessarily prove that he did it, that he admitted to it, right? So unless it's video proof, video evidence of him saying, "Hey, I did this," then things become a little bit questionable. All right, so we're going to switch over to AP here. We're going to zoom this in, and then we're going to mute that audio. I'm going to read some more of the chats here. Even if it's somehow an illusion of everything for me, it doesn't matter because you'll never find out. Same as Jeffrey E. That motherfucker is alive for sure. Oh yeah, dude. Hunter, I am absolutely convinced that Palm Beach Pete is him, bro. I'm absolutely. I think most of us are convinced that he's Palm Beach Pete now. So, let's see. But what can we do about it? Um, well, uh, there's not much. There's not much we can do about it at this point. There's not much we can do about it at this point. Um, uh, what I will say is that history has shown us that cycles repeat, right? And when people snap, right? And that's when chaos ensues. So what I'll say is that people will do things after they snap, and it'll be bad. And we don't want it to get to that point because we want to live in peace. We want to live good, happy lives in peace. However, that's just not the reality of things. So it's not what we can do about it. It's that what history shows us will happen eventually. And I absolutely believe that. So, again, not much we can do about it, but history shows us that cycle repeats. So, all right, we will find out and the information will be known, but it's up to us, the people, to do something about it and not be exactly 100%. 100%. Yep. Yep. We can march, we could protest peacefully, we could do all kinds of stuff. Okay, do all kinds of stuff. It's just it's just gonna take us to stand as an entire people, not one that's divided on almost everything and anything. You know, so um, yeah. Well, look. Listen. There's another thing. Uh, there is another. Actually, there's a couple of other things that I wanted to share with you guys. Let's see. There was a. Oh, I think this is. Yep. Yep. A lot of people would see this, and they would be like, "This doesn't mean this inconclusive doesn't mean it wasn't it. Inconclusive isn't the same as doesn't match or whatever fucking mental gymnastics that they're trying to use." Anyways, so listen to this clip.
Number 6. What is Exhibit 6?
Exhibit 6 is the bullet fragment.
I'm gonna play that back.
Number 6. What is Exhibit 6?
Exhibit 6 is the bullet fragment, the bullet jacket fragment, as well as some other.
Okay, so here's something that I wanted to point out. Why is she so nervous? This is the same question that I had yesterday. Why is she so nervous? Right, chat? Why is she so nervous?
Fragments that
she wasn't this nervous day 2. Right? She wasn't this nervous day 2. So I want to know, why is she so nervous? What was said to her? What was relayed to her? I want to know. because there's no reason for her to be nervous. If she has information, right, that would be damning evidence against Tyler, why would she really be nervous? Because she is having to disclose information that she probably shouldn't be telling, which is what I'm insinuating by saying I think this is the defense asking her questions here. So
Or recovered from Mr. Kirk at the time of autopsy.
Thank you. Going back to page 2, will you read the first full paragraph there, beginning with Exhibit 6?
Yes. Exhibit 6 consists of one .30 caliber class deformed damaged bullet jacket fragment and 4 lead fragments.
uh-oh.
Will you read the next paragraph
Hang on.
as well?
We're gonna finish this out.
The Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1 rifle based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The results of the comparison was inconclusive.
Uh-oh. Uh-oh. Whoa. Inconclusive. A lot of people jumping through mental gymnastics saying, right, that doesn't mean that it wasn't a bullet. That doesn't mean that wasn't the bullet. It means inconclusive. That means it's not a match. Which means if you are trying to match a bullet that was used in a crime and you can't match it, it's not the fucking bullet, bro. Look, there are two things that are certain in life. Yes and no. Okay? If it's not a yes, then it's a no.
Paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their
How's the audio,
ability
guys?
to comply with this court's orders. And they acknowledge that they understand
Yeah.
the order and that they can comply with it. And the court asks them if they have any problem with it, and they state.
Your Honor, I object. The victim was struck with a 357 Magnum round. But there's a spear sticking out of his head.
Would not be
You know,
published.
audio's
to the
good?
electronic
Nice.
Media,
Okay. All right.
and it was.
BRB, guys, I want to go grab
And
some more coffee,
without
and I think I have to
belaboring
use
the
the
point,
restroom, so
the court
be
can
back.
imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it.
Yeah, spear, bro.
It is concerning, and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary
Cock and
hearing.
throat.
So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed, and then obviously if there's a part two, then therefore to that.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was not
Novak.
trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Quick question, chat. Why is this taking an entire 5 days? Like it's taking a whole week. Does that seem a little scripted to you?
I think at the outset it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on.
Well, I mean, it is the preliminary case, so it has to be it has to be day after day. I don't know if that's not normal, but I mean, I would imagine that's how it plays out, right?
I want to weigh this and taking in consideration, and I find your representations to be
They're trying to find
accurate as
probable
what occurred.
cause.
I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what
My point is, why exactly 5 days? Why is it not 2 weeks? Why is it not 7, 8 days? Why is it not 4 days, right? Why is it exactly a week? That doesn't make sense to me.
To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's 2 exhibits at issue. Those exhibits
That's what I'm saying.
were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that Anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen.
They're talking about the leak.
They're
talking about the leak yesterday.
Other attorneys for the media coalition are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make.
No, why I use
make an
quotations, but
objection.
whatever.
And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction,
definitely was an
caution,
accident.
sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure
already taking a
there's
break.
a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but
How are we already taking a
given the
break?
nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the
Yo, Chad, we got something to look at here.
dialogue between me and Mr. Novak?
We have a couple things to look at,
All
actually.
right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
All right. We have a couple things to look at here, chat. All right, so this is the leak that they were talking about. All right, it's pretty questionable. Why this looks the same as this? Let's see, Luna. If you were reading this, I don't even know what that says. Some of this isn't even legible. Yes, some dudes. A lot of this isn't even legible. How can someone even read this, bro? Like some of these letters are not the same size as others. Chat, how do you even read this? Anyways, some things to point out. Luna, Luna, um, Luna. This is weird, man. But here's the thing. Like this looks like it was written by a fucking 5-year-old. It looks like it was written by a 5-year-old, bro. Same thing here. Written looks like it was written by a 5-year-old. But something to note, and this is what I was kind of comparing to yesterday, right? Where the engravings on the bullets, and again, YouTube, again, anything that I show here is going to be for educational purposes only. Educational purposes only. All right. All right. So let's bring this over here and let's see if we can kind of compare and contrast here. So I was trying to look at some of the letters here, like the A's. The A's are different. The A's are different. So let's see. The A's are different here too. That's weird. Yeah, the A's are very different. How is this the same? What was that? Oh, okay. Got it. How is this the same? Yeah, there's no way. Let's take a look at the eyes. Eyes look like this looks like something someone had. One is Old English A. Yeah, it could be, yeah. Definitely looks that way, doesn't it? Yeah. So there's two different handwritings in the leaked version, and then also here there are two different handwritings. So who did the engraving here? Because that doesn't make any sense. While one is common A and the other is a Q-shaped A. Yeah, that's true. That is very true. What else did I want to show you guys? I think there was something else. Um oh yeah, that's right. I'm gonna have to go to one of my posts here. I'm gonna have to scroll down quite a bit. So something that I found, I think yesterday, was a picture of apparently Lance Twiggs drawing a map of the whole thing. I mean, which is really weird. How would Lance know, right? So I think this is something that really should be brought into the trial, but for sure um the preliminary as well. So let's take a look here. Look at the A's. Look at the O's. And look at the I's. All right. It looks like a little, like a, I don't know, like, a greater than sign, right? Greater than sign. But the A's are very distinctive. Very distinctive. And let's bring up some more of these screenshots here. Let's go to one of the ones that was fired. Let's go to one of those. Oh, that doesn't have an A in there, so let's see. Let's see which one does have an A. No. 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 Oh, that's weird. Let's see. Well, let's see if we can. How are the T's? What about the E's? The E here matches. Right here. E. All right, can you wait? Let me make sure you guys can see that. Yeah, you can. Okay. The E here. E there. Um, look at the way the O's are. The O's are, and that could be the same thing there, right? How did how why was this not brought into anything? I mean, that's very clearly the courtyard, just what southwest I think of the Losi Center, right? But this is the courtyard here, the quad. So that's so interesting. Why was that not brought up? I've been trying to verify that this is actually Lance, but you can see that these the handwriting here matches up quite a bit. Only thing that doesn't match up are the eyes. The eyes are done differently. But then again, using a Dremel, you know, makes sense, right? But this is what I found yesterday. Someone had apparently someone has been trying to get this information out for a while. So shout out to you guys who are finding this stuff. Uh, so, but that's really interesting. That's very interesting. Well, yeah, I could. Yeah, if no one if it can't be proved, if it can't be proven that whatever. Yeah, that's a good point. That's a good point. All right, and there's something else that I wanted to show you guys too. Um, huh. Hang on a second. That's something. That's something different. Here, hang on. Let me bring this up real quick. Kind of compare these two. Well, that's interesting. That's interesting. Where's where's one of the swivels for sling mount? Ah, interesting. Here, I want to take a screw. Well, actually, no, I have a screenshot of it. So, I want to pull this up for you guys. And this is just more evidence that this is a different rifle. Here, I'm gonna pull that up. All right. Again, YouTube. This is for educational purposes. Okay. All right. Don't take my live stream down. All right. So this is an image that they took that they just put or that they just presented. All right. And here's one they took literally just after. Look at the swivel here. This is a swivel for a mount. All right. Where is it here? Here, let me see if I can move this over. Where is it? It's not here. It's not. Okay, I guess these are the okay. Yeah, those are the same stock length there. Where is it? Because I don't see it. I don't see it at all. Oh, it's only been 10 minutes. Damn. Yeah, that's weird. That's really weird. Huh, I just saw that. I just noticed that. All right. Let's see. I had also pointed this out as well. I did a short about this. Or I posted it as a short last night, I believe. So
recreating the
we're going to
assassination of Charlie Kirk with a ballistics dummy. I also made 4 ballistics
watch this. Here, I want to
necks out of ballistics gel and cow bone that we're going to shoot as well. To make the in slow motion, we can actually see the mold. I used 6-inch drain pipe, which, by the way, the average human neck is 5 inches. The next day, I went down to the gun club that I joined to make this video at the 150-yard berm.
You know, I'm just
Today we're going to be recreating the assassination of Charlie Kirk with a ballistics dummy. I also made 4 ballistics necks out of ballistics gel and cow bone that we're going to shoot as well. To make these necks, I went to my local butcher and got some cow femur bone, which
could be just the angle though.
Is much thicker, larger, and stronger than a human neck bone. For a mold, I used 6-inch drain pipe, which, by the way, the average human neck is 5 inches. The next day, I went down to the gun club that I joined to make this video at the 150-yard berm. I got some Federal Blue Box 180 grain soft point hunting ammo. I got the first 2 necks set up and then took the first shot. In slow motion, we can actually see that the bone not only didn't deflect the bullet, but it exploded into several pieces. Keep in mind, the FBI's official story is that Charlie Kirk's neck deflected the bullet down into his heart. Somehow, I have a hard time believing that. Now let's take shot number 2. In slow motion, we can see I was slightly less accurate on this one, shooting it in the bottom right corner, sending it flying, spinning in the air and knocking half the ballistics gel off the bone. It also sent debris about 20 feet away. Here on the left we can see the one that I shot in the corner and the bullet mark that went right through the gel. Being as the other one was exploded, I went looking for pieces of it and found one here on the railroad tie. The other piece I found back here laying on the berm.
Yeah. So yeah, there's no way that it was a 30-06. No. No. People were absolutely pearl clutching at the 30-06, bro. Absolutely not. Really go to geometry. Angle was only off by 30 degrees and 10 degrees off to the side. That was accounted for in my assessment. Well, so as I was showing you with Valhalla's angle, the only way that because the official narrative is that Charlie was struck into C2, right, and the round crashed because of the redirect after hitting his vertebra, crashed into a C7, right, and lodged there. Um, so for that to happen, it would have to come at a specific angle, right? Which is more of a what I think a 30-degree angle, something like that. But even at that, for that to happen, your C2 is like right here, right? Your C2 is right here. So for something like that to happen and hitting you dead on, right? It would have to go through your face, right? So that doesn't make any sense. So anyways, I have to use the restroom, guys. I'll be right back. BRB chat. All right, I'm back. Appreciate you guys. Coffee is a diuretic, and coffee moves through me like a university cheerleader captain moves through a football team. So, so uh, I think we're done with coffee for the day, though. So it's probably gonna be the last time that I'm gonna be cutting, going to the bathroom. Okay, so you were talking about the stock of the okay, got it. You're talking about the stock of the rifle. Okay. Um, let's see. Someone pointed this out. Thanks, man. I appreciate that. Glad to be back. Someone pointed this out, which is a little suspect. Oh, that looks like a hammer. I know for a fact that looks like a hammer right there. That's pretty convenient. I don't know iPhones. So can someone tell me where the time display is for the iPhone? Because I'm pretty sure it's here, but I'm not exactly 100% certain. "21 minutes? What are you talking about?" Yeah, that looks like someone smashed it right there. That absolutely looks like someone smashed it. Yeah, this doesn't that doesn't make any sense to me at all. It absolutely looks like, because you have dead pixels here. Yeah, that's an indication of a specific point of damage there. Oh, um, I don't know. Maybe
ABA, thanks for the super. Text say, I planned this a week ago. Lance interview said he was engraving bullets a month before the event. Someone is lying.
Yep.
Exactly. It's not adding up.
wait.
And everyone's keeping
Lance
track.
interview.
There's
He said he
thousands of
was
people
a
that are keeping
month
all these
before.
details in mind.
Ah,
Mm-hmm.
interesting. Interesting. That's very interesting. Yeah. So they're also waiting too. So it looks like we're still, yeah, we're definitely still live. So damn, doesn't it pay off to be a fucking bigger YouTuber? Doesn't it pay off to be a bigger YouTuber, bro? You've got all of these deets, man. Got all of these details, bro. That's crazy, dude. One of these days, chat. One of these days we'll be a bigger YouTuber. One of these days. One of these days, Alice to the moon. So yeah, that's definitely an indication of someone taking a hammer to that specific spot. Does that look like a screen protector though? Here, let's check this out. Here, I'm going to screenshot that. I'm gonna screenshot that, and then we're gonna take a look into this here. Maybe it's not a screen protector, which would be really interesting. That'd be really weird. Uh, Full battery, that doesn't make any sense. How many people do you know that carry iPhones has a full battery? Guys, how many people do you know, especially this day and age with this younger generation? How many people do you know has a full battery? Looks like a glass breaker hit, not a hammer. the reason I say that is because this is it doesn't look like a glass. It does not look like a window breaker. No, this would look a lot different. This would look a lot different. Um, there would absolutely be a hole here, right? I have 4, and they are never full battery except when they come off the chart. Exactly, exactly. No, but there would be a hole here, and there wouldn't be this because there's a dead zone right here, and like I said, there's also this is in this right here is what I'm mainly looking at when I'm taking a look when I see blunt force damage, right? It definitely looks like a flat surface hit it. Elsewise, there wouldn't be this dead zone. But these dead pixels right here indicates that there's absolutely
Be seated. Court is back in session, noting the
a
presence of
blunt
counsel
force
on all
there.
parties, and where we left off
So-
as the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure
Well,
it's
there's a
given
protective
the weight it
plate and
deserves,
Gorilla
and it
Glass.
is deserving of every moment
reacts
that
differently to-
has been spent. Mr. Novak, turning to you.
Well, true. I understand what you're saying, but a point like that, no, it doesn't matter if it's Gorilla Glass or not. It's gonna react a specific way.
And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16.
I guess
was
we'll have to
delivered-
test it, right?
was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected the camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded,
Yeah, there's something that I thought about too was the messages absolutely go into the header a little bit. I didn't know if that was due to possibly the glow or maybe some glare, but that doesn't look right either. That absolutely looks like the messages are going into the header there. So yeah, that's interesting to me. Also, yeah, that doesn't make any sense. Um, yeah. Again, I don't use iPhone. I don't use iPhone because I'm a normal person. So, you know, yeah, this doesn't make any sense to me. I was going to point that out earlier, but I wasn't exactly sure. So now that someone else has seen that I think there's something to that as well.
On my memory of reviewing this last night, in the recess, I reviewed the feed again, and what you have said today is accurate.
"Thank you." Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio.
What?
This is the second time
Dude,
that the court's order.
was that on purpose? Was that leak on purpose so that they can stop any and all fucking media from recording this shit? Was that on purpose?
Which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the requests for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be. Just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests, there were requests, and those that were timely were all granted. The court denied one request because it was not timely for one particular day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's a fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here, and of course the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying Motion 305 and grant it for the balance of all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor, as to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist, and I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing, deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
So there is a new portion of evidence that I have to share with all of you guys. It turns out that the leaked, or not the leaked, but the presented evidence of the text messages were not actually correct. So give me just a second, guys, to pull all of this up for you. I'm going to pull this up for you guys. Here is Exhibit 31 or whatever. This is the actual text messages. All right. The actual text messages here. Read this. My dearest Lance, I wrote to thee with a burdened heart, for I must unburden my soul unto thee alone. What hath befallen this day will scarce be believed to be any by any. Yet it is the truth, and thou art the only one to whom I may confess it. Tyler, what meanest thou? Thy words are heavy with mystery. Hast thou done aught rash? I pray thee, be not angered. Be not angered, my love. Nor think me fallen from honor. This day, at the gathering where Charlie Kirk did speak before the multitude in Utah, it was I that ended his life. Good God, sir, sayest thou in earnest? Thou hast slain him? In sober truth I did. From a vantage point upon the rooftop adjacent, with a rifle, with a musket,
Almost done. I appreciate the
I
party's
had
patience.
contrived and brought to smite
This issue
to smite the
rises to
ruffian.
level
I
that
took the shot that
necessitates
befell
great
him.
care. And as my practice, I don't like to rush
Oh,
or make snap decisions. And
It
I
was a
want to give
swift
it the
smite.
full
oh bro, what the fuck?
analysis that it's due. So thank you again for your patience.
He never saw me coming. The ball struck true. Fucking swat at me. The ball struck true to his neck. He fell before he could so much as cry out, "Oh, I've been struck." All right, so that is the actual. Yeah, that is the actual evidence that was brought before the court. So, correction.
Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order.
Yeah.
The court reserves
I knew that's what they were
sanction
going
as
to
it
do.
relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, may call your next witness.
Judge, we would like the benefit of the record before we start taking evidence today.
Yes, Mr. Gernander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge if the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial. We will lodge this objection, but I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases to include State v. Schmidt. Schmidt continues, "This means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial." A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, "The standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense." So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, "The magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial." Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, "so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence." There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, "Under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution," close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses.
Overwhelming.
Within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Gernander. Do either party other parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it, given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burton. And before I have you call the witness, just want to make sure that the media had well, I'm not sure if the media.
I had to get myself and quench my thirst.
Response. All right, thank you.
Get myself a cold beverage and quench my thirst.
Ms. Oliver.
Sorry, I'm a little still a little bit in character from reading that absolutely hilarious meme. Anyways, yeah, that's pretty much
Oliver, if you'd
what
like to
bro
come
was
forward and
saying.
be
We're
sworn in.
absolutely going to go to. I told you we were going to go to trial. There's no way they're not going
swear that the testimony
to
you
not.
shall give in the
Yeah,
case
there's
of
no
any
way they're
particular
not going to trial,
the
bro.
truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer, so I want to make sure your
Well,
voice
I
is
learned
projected.
something
Thank you.
today
What do
that I
you do for a living?
wasn't.
I work for the Bureau of Alcohol,
Looking
Tobacco,
forward
Firearms,
to
and
learning
Explosives
about.
as a DNA section chief.
Oof.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
Someone from they've already brought someone from the ATF. That was yesterday, bro. What I have questions about is why did they take the evidence from the state handed over to the FBI, and then from the FBI over to the ATF? That's what I want to know. In a state trial, or in a state case, I should say, in a state case. Oh, I'm, I'm, I'm looking. Dude, this is going on so long for some bullshit, man. I'm getting bored. I'm looking at the Discord chat. This is fucking. Oh, dude. Uh, that's funny. Oh, I missed a lot of yesterday. One thing after another. I got you. No, it's all right, bro. It happens. Dude. What's Zeta? That's a letter, isn't it? Letter. Zeta. Yeah, that's what I thought. I was pretty sure Zeta.
For instance, the next sample down, 1.2.
Oh, they have someone
Statement,
else from the
paragraph
ATF.
D,
I thought it was going to be the
admitted
same
paragraph
witness.
F.
Well,
You state
obviously
in
not if
F,
they did, if they swore.
Based
they
on
got
this
sworn
calculation,
in.
there is
Sworn in.
evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr.
Oh,
Burt, I just want to
as a
interrupt.
possible
There
contributor.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor, there might be concern about the actual monitors, the council table and the podium. Any clarification on that?
Well, that's why I give my notation to begin the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nine on behalf of the victim representative. We cannot see the court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
The Thank you. I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of the word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please?
Yeah.
And the
No
court
one
has
likes the
heard
ATF,
some
bro.
prior testimony about this Department of Justice directive. What is ATF's, what is your understanding
The
of
ATF
what
should be dissolved, bro.
qualifications
100%.
and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
shall not state that it's
So-
infallible or have a 0 error rate, correct?
Correct.
So they can't say
It
it's
also
infallible
states,
or
does it not,
inconclusive.
that you shall
So
not
what the fuck is it?
assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty,
Correct.
correct?
The
Now, when-
ATF?
You can take that down. When did you
Is it a
first
federal
receive the
agency,
assignment
entity?
in this case?
The ATF? Yes, it is.
I would have to refer to my case record to know the exact date.
It's
do you have
one of
those
the
in front of you?
three-letter agencies.
do
You've
not.
got the CIA, the
Okay.
FBI, the
Let
ATF,
me, pull up
IRS.
Oliver 3 for the witness only.
All federal, except for the Federal Reserve. Federal Reserve's not a federal agency or anything.
And go to the third page.
But then again, it's not a three-letter agency.
Does
anyways,
that
so-
third page
I just
help
wanted to
refresh
say
your
that.
memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Okay, you're good, bro.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
Could I refer to my tables in my report?
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify essentially, what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA
I
testing.
don't understand your question.
It was a
Your whole
report
system is
that looked
cryptic.
into forensic DNA
Did I miss something?
reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? This is Baker 30. Keep going.
It's asking if there's more into the language they use in their report. Oh, okay. Okay. Yeah, federal systems are encrypted. They're absolutely encrypted.
There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included. And then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next
That's a good
limitation
question,
they
Guarded. I'm not
suggest
sure.
you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it.
On that,
you're
on that note, they usually like to use bigger numbers to confuse people. So you could say that, yeah.
That's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second
Rain,
report that you wrote had to
nothing
do
else,
with
dirt, the
a
elements.
Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to a what's called a POI, person of interest.
There's a lot of factors.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to, say, swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay. And if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
was-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There was support for inclusion of Matthew Robinson.
Okay. And next page, actually go page to page 7.
That's interesting. That's a
You
new
found
development.
Support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is You're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a
Could be jumping ahead of
forensic biologist's
myself.
tool belt.
Okay. Now, could you go to
Thought that was interesting.
154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
They've already found
No, you were right,
that
154.
there's more than Tyler Robinson's DNA on the evidence. They've already found that, so I don't.
Yeah, this is one, what's the exhibit on this? Okay. You're familiar with this chart, right?
I've reviewed the first page of this chart. I
Sure.
have not reviewed the entire
Go to
thing.
the first page.
Why would you
This
not
lists the
review
alleles that you
entirety
found,
of it?
correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison, so it's not just number matching. We're using STRmix, the StarMix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Right.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A.
Is
a
that always
17B,
the
and a
case though?
17.
Like for twins, are since they're identical twins, are they going to have the same allele type? Or is that indicative of a different person always?
Referenced.
That's
when I
important.
object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection, it will be reframed, and we'll go from there.
It's true, is it not, that at least 1, 2, 3, 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles.
It could be, but
and
they're
therefore
identical
it
twins,
goes
right?
to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she
So
didn't do it, and therefore
theoretically,
she's not in a position
their
to
DNA should
draw
be the same.
conclusions.
Mr. McBride?
But perhaps DNA structurally may be just
That proffer
a
is
tad
inaccurate.
different. I don't know.
That she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant.
Right,
to her testimony.
and Agent
see if I
Hull
could
doesn't
lay
do
further
autopsies,
All right, so I'm
so
going to sustain the objection, and the question may be reasked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared
I don't think I've
a
ever
non-match,
studied genealogy.
regardless of how many other loci match.
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So
The best that I have
it's possible for DNA
information-wise over genes and traits and stuff like that is the Punnett square. So we're both lost here.
that some of the profile has.
But I think I'm
dropped out.
understanding.
So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends
Again,
on,
objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt.
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say
Right, that's what I was about to
the profile is
say.
consistent with at least 4 contributors. I assume by the word "at least" you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in
Chat.
sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures.
4 to 5
Familiar with
at
that, right?
least
Yes.
contributors.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
You said you're referencing my SOP.
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with probable cause determination. Even if it's
Yes, it
difficult,
does.
the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying this is going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you
the
bring
question
up
can be rephrased.
one, exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83.
What? Dude, that's crazy, bro. That is crazy, man.
Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, and trying to decide if a break is warranted or if, Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go, I'm just trying to weigh whether we should take a break.
I will probably be, I will probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr. McBride.
Right. How can they tell who did it if there's at least 4 or 5 different people's DNA on the evidence? If Tyler acted alone, then why, for one, is Tyler's DNA not the main
Good morning.
DNA found on the evidence?
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary
It's the
accreditation
ATF.
process where a external third party comes in and audits our laboratory to a set of standards. Specifically,
Oh,
the ATF
really?
laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025
Right.
for testing laboratories.
Not
And
as
additionally,
not as reliable
DNA
evidence.
Specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're
Yeah,
required
that's a huge
to perform
discrepancy.
competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes,
And at the time you did the testing in this case, did you satisfy those standards?
yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30. If we can pull that up, just for the witness.
Bro, that had to have been staged, man. That had to have been staged with that leak. That has to be staged, bro.
Thank you, Kimberly.
That absolutely has to be staged. There's no way it was it. There's no way it wasn't staged.
We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case is
Nice. Let's go.
Let's
Glad
jump
the
back
wife
to
made it
page
home safe
7.
and sound.
And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of two individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together, is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Yeah, man, you got to get to sleep,
You can't tell
bro.
us anything about
You got to get to sleep,
whether,
my guy.
when you say it's
please,
at least
please
4,
go
it
rest,
could be
man.
5, 6,
Go rest, bro.
or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
Decompress before dropping the kit. Oh, I gotta let her decompress. Oh,
You said Exhibit 1.1?
Yes.
I get that.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay.
Well, I don't got it, but I
And
can't.
again, with regard to all
I
these
can't just
samples,
drop that. Yeah, no.
no way of knowing when or how the DNA got on those
No,
samples.
people
Correct. You
need time to
referenced
kind of
another-
adjust. You know.
Statistic in your report
I don't know if she just got home from
Which
work
is
or
the
something, but
statistic
especially if it's work,
related
yeah,
to paragraph
you
B, I
have to
guess.
mentally switch
Correct.
Is it what's
from
called the
work
random
to home
match
life.
probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't
Oh,
state
okay.
it's
Then, yeah.
infallible. Can't state there's a zero error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused? All right. Thank you, ma'am. You may step down. Anything further from the defense?
She volunteers there once a week.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1 so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right. In regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff and I, on behalf of the victim, my understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we...
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right. Nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the stage. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right. And as it's switched to audio only, to the state, now am I understanding there's no audio on this surveillance on 12.1, is that correct? All right. All right, so let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured, the screen, in any way. I noted video recording, but I intend as well as no still capture of any of the monitors during the publication of 12.1. All right. And to the stage, just let me know if you're ready. Let's go ahead and play it now.
Okay. I'm looking at, as we're going through, I'm checking X. Because a lot of people post on X. I'm trying to catch anything that would be notable of concern to talk about. That's interesting. Okay, so something I wanted to note while we're waiting. While we are being distracted by the Tyler Robinson case, this is this is happening. So this is your reminder that as we are paying attention to major news, that we should also be looking into what potentially might be happening on the back end. So here we go. There you go. It's going to be a little bit of news for you guys there. And so, just to confirm, yes, they are stopping all media for being shown.
Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. Effective immediately, members of the media shall no longer capture or broadcast any exhibit.
Yep. I figured that something like this was going to happen. It absolutely makes sense. So, also, never ever stop talking about the e-files. Never ever. This is disgusting. Whoever this is should be investigated and receive capital punishment. That's disgusting. So, there's some interesting things that are going on, guys. Interesting things are going on. Also, I don't know if I can show this, so I'm not going to. Let's see. On X, breaking, our greatest ally dropped a new type of bomb in Gaza. Palestinians described it as a miniature nuclear bomb. But analysis suggests it's most likely a thermobaric vacuum weapon. Let's see if that violates the international law. Does using vacuum weapons violate? Yeah. Well, no, not Moab, no. But a micro nuclear bomb, yeah. Use of air weapons does not violate the laws of war itself, but their deployment against civilian populations or populated areas is strictly prohibited. I mean, there's really no telling if that's... I mean, you can't even really tell where the houses are anymore. They've pretty much glassed the entire fucking thing. No, not a again, no, not a Moab, no. No, that's something very, very, very different. Something very different. You want to talk about Moab, think Nagasaki, Hiroshima. But no, this is something different. This is a thermobaric vacuum weapon. Okay, it creates a vacuum and a pretty devastating shock wave when it's hit. So yeah. I don't know what that is, so I'm gonna have to watch that a little bit later on. Oh, also this was updated. Huh. I was thinking about the effect being similar, not the, oh, okay. Not necessarily, because it has more to do with the shock wave. Whereas the Moab typically deals more with radiation and visceration. So Let's see. So I fact checked it. All right, guys. So check this out. The Iranian army just posted this. So this is supposed to be apparently they made a prison specifically for children where a lot of really bad stuff happens. So I don't think that violates any.
All right, and that concludes the playing of
No, that doesn't violate
12.1
TOS.
video.
So then I fact checked it.
Transmission may resume.
I fact checked it.
Just let me know when that is live.
And that's true.
All right, thank you.
Yes, it's a nuclear bomb. It's an atomic
Does
bomb.
either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing.
Oh.
The court will allocate up to 4 hours total for
I was wrong.
argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
Whoa, hang on. What the fuck did we just miss?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel.
Okay, let's see what the live chat is saying. All right.
That's it. That's the prosecution's case. We saw all their evidence.
I
Not
saw a
much.
post. I saw a post on X where someone compared the security footage from Dairy Queen to everything that we've seen. It's like everything of Tyler Robinson from UVU is blurry, but like Dairy Queen has like top notch footage.
Mhm.
Like everyone else on the planet has like decent quality cameras in front of their homes and in their cars and everything. But UVU, everything is potatoes.
Even though their
Potato
cameras are
cam.
all brand
Conveniently.
new. They're all brand new, I guess, as of like the last year. So
All right, I guess what's going to happen is they're going to consider going forward if there's enough probable cause to go forward with trial. So that's going to be a couple of months away. Or yeah, just about a couple of months away. So the prosecution's entire case, their entire case is hearsay and shoddy footage that Nissi just pointed out is absolutely terrible fucking footage. Terrible footage. again, my phone does better. My phone has better quality than these cameras. But conveniently, right, just as we were talking about yesterday, very conveniently was these or were these cameras in place, put in place, right? So I find it extremely hard to believe that these cameras are anything but reliable at this point. I mean, some of them you can't even really tell where half of Tyler Robinson's head even is, right? Let me see if I can pull up some of these images here from the. I might have to go to my X real quick, my Twitter. So let's see. There's a point in one of the camera footage, one of the compilations of more than likely doctored camera footage, where Tyler supposedly like just blends in with a vehicle, the concrete floor, right? Blends in with several different parts of the uh the video, right? Which would suggest that it's AI. But then again, a lot about this case is AI too, right? And let's not forget uh did Agent Hull did he write his report using Chat GPT? Here we go, right here. This is the picture that I wanted to share with you guys here. So I'm gonna pull this up. And so where is half of his head at? Where's half of his head? Right? And then also look at the vehicle. You do see a bumper here, but it blurs. The tire blurs into the street, the floor. His shoulder blurs into the floor. His shoulder also blurs into the vehicle. So apparently Tyler Robinson's made out of more than flesh and blood. Apparently he's made out of metal, just like the Man of Steel himself. And then also made out of earth. Bro's made out of concrete. He's a golem, bro. He's a golem. That's why he hasn't been taken out, bro. That's why they took 33 hours to find him. They couldn't figure out what his name was. Moab relies entirely on standard high explosives to generate a massive blast wave. Okay. It's not produce iodized. Okay, we checked that out. You're right, bro. I thought for some reason that it did do that, but I was wrong. I was wrong. Um, but yeah, strongest evidence, strongest evidence they have is absolutely hearsay. It's they tried to present a non-expert as expert evidence through hearsay, mind you, and they thought that was sufficient enough. So complete utter bullshit. Complete and utter bullshit. Um, no, this is a different kind of weapon system. It's a vacuum weapon. It's not a um wait, hang on. Oh. Um I mean it depends. It depends on what was used. I don't know. Um yeah. Watch this though. This is pretty interesting. All right. This is how Tyler Robinson did it, guys. This is how Tyler Robinson did it. This is how Tyler Robinson did it, guys.
41. You remember that image of the gigantic cell phone sitting right here in the thigh? That's your stock. That explains why the leg motion cannot come forward, because it's completely locked in. And if you see, I'll put the video or the image up on the screen in the photo, you can start to see an outline of the stock, okay? This has solved the riddle that has been bugging me the whole time about the bulk of the stock. Essentially, I believe now with 90-something% certainty that the stock was carried this way and the barrel was carried on the side. Now, whether or not the scope came off or not, that's an item for debate, and we can talk about the ramifications of that later. But I think with certainty, or you can't be certain about anything, but I think is close.
Oh, he had to catch himself there. All right. Where in the fuck do you see any silhouette? Let's pull up. Let's pull up that footage real quick. Let's pull up that footage. Let's pull up that footage. All right. You know what? I'm probably going to have to go back into my history instead of just looking it up. I'm going to have to scroll here for a couple of seconds, guys, so just bear with me. I do post a lot, so it's going to take a few seconds. I post a lot, bro. But it's not gonna take me long to find it. Right? I don't notice a bulge. I don't notice there's a bulge. Dude, that whole thing is that whole thing is ridiculous, man. It's just ridiculous, bro. There's no way. There's absolutely no way. All right, this is taking a little bit longer than what I thought. This is crazy, dude. Where? Come on, where are you? Where are you? Yeah, I'm having to go back. Oh, is that it? Hang on. That's pretty zoomed in. Yeah, that's zoomed in. So let's take a look at this right here. Let's take a look at this, and let's just compare. Yeah, you don't see. Here, let's see. Let's do a screenshot from here, and then let's also do one here. And we're going to take a look at the pants and see what we can see. All right. So okay. Is there a better angle? Oh. Oh, did you see that, guys? He takes a step. And he goes, oh, wait a minute. That wasn't in my script.
And the photo.
He takes a step and he's like, "Oh well, let's not give them that angle. Too late, buddy. You already did. You already did." And dude, those are some baggy pants too. Chat, those are baggy pants, man. Those are absolutely some baggy pants. So let's take a look. That's baggy. These are more. It looks to be form fitting. That absolutely looks to be form fitting. Right? You can clearly see the outline of the legs. Here, you can't do that. It looks like he's trying to hold. There's no belt loop there, or there's no belt through the loops, right? So it looks like he's trying to hold not just the rifle in place, but also the pants or the buttstock, but the pants as well. This is so disingenuous, dude. This is absolutely disingenuous to try and prove a point. This pants looks loose. And again, this looks form-fitting. Right, chat? I carried a katana in my pants before. I know a rifle would be harder to hide. Oh, okay. Is that how you met your wife? Is that how you met your wife, bro? Are you a samurai or are you just happy to see me? Where's the honeymoon? Is it in Osaka or is it in Kyoto? Yeah, even so this is more aligned with this angle here, right? And this doesn't, no. No, absolutely not. Absolutely not. Here, let's see if we can pull up the video here. Let's see. Can I pull up the tab? Yes. Okay. All right. Yeah. I mean, there's no way. There's absolutely no way, dude. There's no way someone is fitting a rifle. It would be way too obvious. It would be absolutely way too obvious. And then I saw someone else try to do the same thing, and they looked like a complete dumbass. Bro, I've never seen someone look more dumb in my entire life, bro. This guy was so fucking stupid. The fucking mental gymnastics he had to go through, bro, had to have been influenced by LSD. Like I like I'm serious, guys. There's no way that someone would actually make a video like that and think that they are making a valid point. There's absolutely no way. So, but I'm going to show this to you guys so you guys can see how dumb this dude is. Here, oh wait, I think that was before the trial. Or maybe not. Maybe no. No, okay. So this was oh. Oh. The Misfit Patriot. You're absolutely right, bro. You are a misfit. You're a misfit on the internet, bro. You're a clown. Stop. Get off the internet before you make more of an idiot out of yourself, bro. Oh hey, oh wow, he's also wearing more form-fitting jeans. Must be a little bit more plausible than what we thought, right? Maybe not. Maybe not. And then bro has to lift his shirt up so much just to take it out. Dude, this guy is such a fucking idiot. Then he takes it apart, and it's still sticking up. The silhouetting is still so blatant. Anyone can see that and be like, hey, what's going on with that guy? That's not right. Nah, dude. No. No, there's no way someone's doing that. There's absolutely no way someone is doing that. No. No, it's just Chad, it's not gonna work. It's not gonna work. Right? Something I didn't share just as of yet were the bullet fragments, which I mean they already said was inconclusive, but let's take a look at it anyways. Let's take a look at them anyways. Just for our peace of mind, right? Just for our peace of mind here. Let's take a look at the bullet fragments. And let's just compare the two images that they put up. Oh wait, did I think I took a screenshot of them. So what am I doing? What am I doing here? Ready for sleep now? Phone's at, okay, that sounds awesome, bro. Yeah, I'm not gonna be on too much longer either. So you have a great night for you. Sleep well, man. Take care of yourself. Appreciate you for popping in here, man. You are the goat. You are the goat, bro. Everyone say goodbye to guard it. Sleep well, man. All right. Because what I'm gonna do is I'm gonna go and cook something up because I'm starting to get hungry. So hello. Oops. Okay, there we go. All right, so let's just compare these two rounds here. All right. Let's compare these two. Again, YouTube, educational purposes. All right. Look at these fragments. Look at these fragments. Right? You see this here. We'll catch you later. If you're on, as long as I'm not busy with the well, I appreciate it, man. I don't think I'm gonna be doing an art stream tonight. I think I'm just gonna be doing more arc stuff because I really want to get ready for the boss fight. So, Amma, welcome back in. Oh, Amma, you want to see something crazy? I'm going to show you something crazy. Watch this. I was left absolutely speechless when I saw this. Not only are people dumb enough to be Trump supporters here in 2026, but some of them actually believe that Trump is God. I shit you not. I wish that I was kidding, but I'm not. I've seen it all at this point. I have seen it all. Here, hang on. Where? Dude, there's no shot. There's no shot. There's no shot that they took it down. Bro, there is no shot. There's no shot that they took that down. No, I don't believe it, bro. I don't believe it. Hang on. There's no way. There is no way. Dude, that's so... What the fuck, dude? No, bro, that's so weird. Right here, let me go to my YouTube. I'm gonna go to my YouTube. Might be on my YouTube. I don't post as much on my YouTube as I do my X. So, let's see. Is there a way that I can search? I should be able to search, right? There we go. Okay. Okay, well, I have a video covering it. So, let's see if I can pull that over. All right. Here we go. I want to come back to this here in a bit. Oh no, okay, that's something different. Let's see. Who remembers who remembers this fucking this absolute travesty here? Because I remember it, right? I remember when Trump literally made himself look like Jesus, right? So check this out. Came across someone who I was arguing with on X, who literally was bringing up was quoting scripture from Corinthians, from Paul's letters, mind you, as if he's some kind of credible source, right? So anyways, you know. And bro, literally, I told this guy, go and enjoy your Trump Jesus. And he said, oh, I already do. No such thing as coincidence. Last Adam, last Trump. There are people who literally believe that Trump is Jesus. I wish I was kidding. I really do wish I was kidding. But I'm not. I'm not. But then you also had Paula White, who is a televangelist. If you guys don't know about televangelism, I know quite a bit about it. They're grifters, absolutely. And the fact that Trump appointed Paula White as his spiritual advisor after the other one got arrested for doing not so great things to kids. And then she was not only calling him Jesus, but calling herself God as well, right? Because she's literally said that the ground she walks on is holy, right? So, yep. So yeah, same here, man. Same here. They're absolutely atrocious. But did I? Oh, I went over the whole conversation. Did I go over the whole conversation? Ever heard of The Last Adam? But maybe you're an atheist. Never mind. All right, tell him I'm not an atheist, but I don't believe in your bullshit religion. Oh, dude, I'm a little. Look. If you guys follow me on X, you know that I'm a little bit of a troll. Okay, you can get away with a little bit more on X than you can on YouTube. So I post some shit on X all the time, dude. And I'm definitely a little bit of a troll. So we go further down. And okay. All right, let's see. And you'll see it too. 7 resurrections and 27 resurrections and counting. Only one soul has the power over. Okay. Yeah. Where is? Let's see. I am his close personal friend. Dude, these people are sick, man. They are mentally sick. Okay. They are mentally sick. I was just blown away at I was legit left speechless, bro. I was left speechless. So, yeah, to be a Trump supporter in 2026, one, you're already in a cult. But to believe that he is literally God himself, that literally takes the cake, bro. That takes the cake. And I it's I I I don't I don't understand it. I really don't understand. I don't understand how someone can be that well, okay, well, no, I won't say that. I know how someone can be that brainwashed because I've been through multi-level marketing companies and I know, which guess what? This president has also been involved in multi-level marketing companies. If you don't know that, I also talk about multi-level marketing companies. To which I have hardly ever heard any other content creator talk about how our president is involved with multi-level marketing companies. And I've been screaming this from the fucking rooftops, right? But no one else still talks about it. No one talks about his connections to Amway. No one talks about his connections to American Communications Network. No one talks about how this administration is so far fucking corrupt when it comes to multi-level marketing companies. I am the only one that's talking about it. Why? And when I share this information with other content creators, it goes in one ear out the fucking other. It really frustrates me. It really frustrates me that I'm trying to get information out that Americans need to know about. And it's like the only thing that these bigger YouTubers ever really fucking care about is live streaming over major fucking news. They get their fucking paychecks, and that's it. Sorry, I'm fucking venting here. Fucking venting. It's so annoying. Why is it that the smaller content creators are the ones that's actually doing the fucking work? Right? Right, chat? Right? I think that's why people are turning away from larger content creators. But whatever, bro. It fucking frustrates me, man. Like you send this information up to, and you don't really hear anything back. You know, it's really frustrating. So, yeah, there's a lot of there's a lot of things that doesn't make sense. We talked about the rifle earlier. We talked about the rounds. Oh wait, we didn't really talk about the rounds, did we? I got we got distracted. We got distracted. So let me pull those back up. All right. Again, YouTube. Again. YouTube. Educational purposes only. YouTube. Educational purposes only. Don't take my video down. All right. So let's take a look at these rounds here. Actually, let's see if we can. Nice. All right. So you see how there's a little bit of there's some flowering, right? And this right here, well, there's more of a flat bottom here, but not so much here. And there's kind of a ramp that kind of goes up through here. This is different. It's absolutely different, right? Because this here, or maybe here, hang on. There's there's like a wing that kind of just jolts out here, but this folds back in on itself, right? And then this doesn't. This absolutely does not. I have no idea what this is. This this doesn't really make any sense. This does not look like this. So these look like two different rounds. Excuse me, two different fragments. So this doesn't make any sense. Right. You can see a bottomed out round that was used here. But and this definitely would not happen if someone was shot, right? First of all, it's going to go right through, and maybe with hitting vertebrae bone, something hard like that, would probably dent it or damage it in some way. But it's not going to do this. This is like if it hit concrete or maybe more another form of metal, right? Steel, we could say. That's the only way that this would ever really look like this. But definitely not flesh for sure. Definitely not flesh. So, but I absolutely believe that they're going to say that there's enough probable cause, and they're gonna take him to actual trial. So it's to be expected. It's absolutely to be expected. So I knew this was good. Oh, here's something else, chap. Here's something else, right? A little bit earlier, they were arguing. I believe the defense was arguing the case for shutting off all recording of the evidence to be shown to the media. I believe the defense was arguing that because of the leak. I think that was planned. There's no other way. That accident was planned. I think that was absolutely planned. What do you guys think? I think it was 100% planned. So that no more evidence was to be shown. It's just as I've been on X, right? I've been looking at a lot of this new stuff that's been coming out. They're dude, the internet don't miss, bro. The internet does not miss. They are ripping the public the public court, I guess, is ripping the mainstream narrative apart. They are ripping the mainstream narrative apart, bro. There's no way. I absolutely believe that was staged. It had to have been planned. It's just too convenient. It's way too convenient. But again, reminder, look, yes, we're covering the Charlie Kirk stuff, but also make sure that you are watching out for stuff that might be happening behind closed doors, right? Stuff that we're not really paying attention to, such as the National Defense Authorization Act of 2027. All right, we got to keep tabs on that. We got to make sure Section 219 gets out of which was renamed from Section 224, I believe. But we got to get rid of that. We have to get rid of that, and keep tabs on what that's looking like. Also, we talked about how BB's son literally changed his name legally, right? During some through we I guess we found that out through tax documents, but that's interesting. That's very interesting. Also, our greatest ally is using some really dangerous weapons, and violating, are committing yet more war crimes. And then you also have um, some stuff coming out in the e-files as well, right? Well, perhaps no, I can't say that. Perhaps it's been out for a while now, but never stop talking about the e-files. Okay, never stop talking about the e-files. We have to make sure we stop. We do not stop talking about it. We keep talking about it. We keep demanding. Oh, and here recently, another federal judge has also forced the DOJ to release unredacted e-files. Right. So the DOJ is almost over 200 days now, I think, late on releasing all of the e-files, right? So it's pretty convenient that what happened with Charlie happened when it did, that Venezuela happened when it did, that Iran happened when it did, this trial is happening when it did. It's all about the e-files, bro. It's all about protecting the e-files, man. It's all about protecting the e-files. So make sure you guys are doing your due diligence. Okay? Make sure you're doing your due diligence. So this whole thing fucking reeks. And if there's anything new, I'll be sure to make some videos, put them out there. For those of you who primarily watch me on Kick, talking about you, Ama. I don't know if I can actually post videos to Kick or not. I'm pretty sure it's just a streaming platform like Twitch. But I will definitely be posting to YouTube. So I have my platform on YouTube is quite a bit larger than it is anywhere else. So so I will be posting to YouTube, well, and X, but it maybe Instagram. Anyways, I'll be posting to those platforms. All right. So if you guys want to catch those videos and whenever I do them, that's the place to look. So, but went over quite a bit. I'm surprised that it didn't go any further than what it did, but here we are. So make sure you guys leave a like on your way out. Leave a follow, subscribe, join the family, guys. I appreciate that. We are going to continue the fight to expose these evil motherfuckers for who they are. So, but anyways, I'm gonna go ahead and end it here. I'm hungry. I want to go cook some lunch, eat lunch, and I think later on today I will be doing some more gaming content. I'm pretty sure. I don't think I'm gonna be doing a art stream tonight like I usually do on my Fridays. I just not really feeling up to it right now, so I will probably instead just be doing some gaming stuff. So if you guys want to catch that, feel free to stop by then. Love to have you guys there. So, but anyways, you guys take care of yourselves. If I don't see you tonight, I'll see you guys soon. I love you all, and I will talk with you guys soon. Bye, guys.